audible and visible to everybody?
Yes, you're audible and visible, sir.
So can we start?
Yes, we can start, sir.
What's your good name, please, on the other side?
Manoj,
Sir Manoj.
Right. This side also Manoj. Right. Uh, Good afternoon to everybody. I will start with a surprising sentence for you when I say that Supreme Court is a court of facts. When I say that, I am addressing the question in your mind that we are here for the exercise of drafting. Your presentation or facts in the papers to be filed is very, very important. How we present, in Supreme Court, our honorable judges, they read the matter and come. So therefore, our presentation becomes very important. You would not be surprised, in fact, you would already know that if it's a well drafted petition, you can expect different results as compared to if it is not well drafted. Therefore, I say Supreme Court is a court of facts. Firstly, of facts, law will come much, much later. And therefore, the importance of drafting. You are preparing your matter, you are assimilating the facts, and the way you present. The points that I have picked up some highlight bullet points will be exclusively from whatever experience I could gather as being an advocate on record myself in the earlier chapter. I could, and I would be sharing that with you. Let's begin from synopsis. I'll also want to share with you that I mean to take approximately say 20 minutes with you and share my experience with you, and then welcome your questions in the chat box. I want it to be more interactive. Let's start with the synopsis. There's an SLP civil or SLP criminal. Let's start with the synopsis. Your question is telling you that, well, you need to prepare synopsis in this. I would suggest for the exam and for the actual to follow thereafter, once you graduate to be an advocate on record, you could pick 2, maximum 3 points, which are your best points to be presented in the synopsis. Put them right in the forefront. Also, present them with a heading, because when I'm changing my topic, let the honorable judge know that I'm now changing to another topic. I'll give you an example. Suppose there's a land acquisition matter, and it is a quashing of the acquisition, and you find that the best point to be taken is the inadequate description of the public purpose. So you give your first heading as identification of public purpose dash defective. That's your first heading. And then you make your comment thereunder that this is how the section 4 notification came. It said so. You will quote that part that it says exactly so. Rather than your narrative, you like to quote it that this is the exact language. And then give your comments thereupon. You have selected this as your first point. And suppose the second point in that was that the acquisition lapses on account of the time interval between 4 and 6 notifications. So then you could make heading lapse of acquisition on account of interregnum between section 4 and section 6 declarations. And then you give your comment, and then you might like to close your synopsis. You would like to leave your judge at a particular height. Once he has finished reading your synopsis, he must be convinced that this is a matter in which I have to issue notice. At least convinced, if not fully, at least 60-70%. You would have made out a point. And that point, you up till now, what exercise you have done? You've done your point selection, 1, 2, and then you have done that which of this is 1, this is 2, and you have presented them in a precise manner. And that's the closure of your synopsis. See further how you're going to enhance your synopsis. I am emphasizing on synopsis. The entire discussion with you is not with regard to the exams alone. No. Exam and your experience as a practicing advocate on record of this court. Same, no difference. Now see how you add value to your synopsis. Please remember, your examiner or your judge will read your synopsis and your earlier grounds, because he knows that you would have brought out your best there. That's the first impression on that question. Now see how you enhance the value of your synopsis. If there is a particular finding of the High Court vis-a-vis the point that you have selected, suppose in the public purpose point which I had selected, for example, you find that the observation of the High Court is totally wrong. It had said that this public purpose is not vague. So you might like to quote in the synopsis itself that this was the public purpose, quote unquote, and against that, please give the page number of where to find that section 4 notification in the SLP paper book. You might say bracket section 4 quote public purpose quote, and in front of that page 106 of the SLP paper book. You're adding convenience to the judge. It's enhancing the value of your draft. He can straight away go to 106 and see that. And next, in that synopsis, you would say, upon this point being argued before the Honorable High Court, the High Court made the following observation. Now quote those 2 lines from the High Court order. And High Court would say, well, contention has been raised by the petitioner's counsel that this is vague. We do not find that this is vague. This is perfectly in order, quote unquote. And again, you give against that page 14 of the SLP paper book. So your judge can immediately go to 14 and see it. Everything is designed, everything is discussed around the convenience of the Honorable Court. You are presenting your facts. It doesn't make a difference whether you are presenting it or you are engaging a counsel to present it. Makes no difference to what we are discussing today. Having said that, I'm sure while you are attempting the paper, you would read very carefully what is it that is expected of me in this question. I saw the question papers. Sometimes they would say, please draft out the synopsis and the grounds. Sometimes they would say the complete SLP. Sometimes they would say only the grounds and the affidavit. So please, that will also help you economize the time and give exactly what is required of the question. At times, the examiner would require you to prepare the to memo parties. So he's seeing whether state of Sikkim I'm suing through the chief secretary, or I'm making chief secretary, I'm addressing the memo parties as chief secretary, government of Sikkim, and then writing government of Sikkim underneath, as if I'm suing the chief secretary. No, it has to be government through the secretary. So while you're preparing your memo parties wherever required, that will require your attention. Now come to the grounds in the SLP. Whether it's an SLP, whether it's an application, all these things will remain the same. Grounds. Again, let let the grounds also be broken up into headings. This heading, give a heading, and then one or two grounds which you want to give. Then another heading, and one or two grounds, whatever you want to give underneath that. So the judge knows again that you are going from point to point. Your prayer clause, particularly the interim relief. If there is an execution filed already, you would like to enclose with the SLP copy of the execution petition, because that's often a question, and that's often a hurdle in getting the relief, that where have you enclosed the execution? We are praying for stay of dispossession. Has execution been filed? Comes the court question. Yes, it has been filed and it is enclosed as P11, and that P11 is mentioned along with the along with the list of dates, and also mentioned in the interim prayer clause of the SLP. It helps you, it gives the examiner your thoroughness, it helps the judge. While you're on the list of dates after the synopsis, please enclose all relevant documents. Some amount of time, plenty of amount of time goes into is wasted, I would say, on account of adjournment. Why? Because the relevant annexure was not enclosed with the specially petition. Plaint is not enclosed. It's arising from a civil suit filed in Ludhiana, filed in Amritsar, wherever. And that plaint is not there, written statement is not there. That is, the pleadings are not there. The examiner or the court will see that you have mentioned in the list of dates that plaint was filed, copy enclosed. Thereafter, written statement was filed, copy enclosed, copy enclosed. That helps the court, that helps the examiner also to know that you're thorough. You know the importance that all relevant documents which will be relevant for the controversy are there. Certainly those documents which the High Court is mentioning. One other situation will confront you, that in the facts given in the paper, it is mentioned that High Court has made such and such observations. You would like to take a specific ground in regard thereto. Otherwise, the examiner oblique the court will take it that that is not contested by you in your SLP. And if it is not contested, then that's a hurdle in your way as a petitioner. For example, the High Court records that this particular finding was not on issue number 5 was not challenged before me, and you have instructions to the contrary, that yes, issue number 5 on ready and willing in a specific performance suit was indeed argued. You would like to then in your in your in your grounds raise a specific ground saying that this point was argued and it is incorrectly recorded in the High Court order to this effect. This submission was in fact made. While you formulate, next in sequence would come the question of law. the examiner oblique the court will definitely have a look at the question of law framed, because he knows that here from the facts you are giving it the shape as to how you formulate questions of law. Now he's looking at your different skill. That is how you marshal the facts, how you present the facts, as we were discussing earlier. And here, how you cull out the law from the facts given. So please give it the due importance. Take with me the example of a counter affidavit. I could take counter affidavit, drafting, while we are on drafting. SLP we have seen. Counter affidavit, you would like to controvert all factual assertions which are taken in the SLP, which need to be denied, and denied specifically in your counter affidavit. It may not be taken that this is not contested in the counter affidavit. Secondly, the examiner oblique the court will look for that you have enclosed all relevant documents again to answer the pleas raised in the SLP. You have adequately addressed those questions. There were 5 questions raised in the SLP, and my counter affidavit is only answering 4. So I'm short of the mark. I should answer all 5 questions raised in the SLP. Then my counter is ready and complete. If I have some preliminary submissions in regard to maintainability, etc., then I must raise it in the forefront, in the beginning of the counter itself. Suppose the appeal, this SLP is not maintainable. Why? Because an LPA against a single judge is already maintainable in the High Court concerned. So there is an alternate remedy. You would like to take that right in the beginning. Again, please give a heading in the counter affidavit just after introduction, I so and so, respondent number 4, and then heading. Present specially petition not maintainable on account of availability of alternate remedy. Maybe your heading. And then you say, after the heading is given in a caps, in all caps at the top. And then you might say in the comment that in Allahabad High Court, there is a special bench appeal available against the learned single judge, and that has not been availed of. The petitioner may be relegated to that remedy. You're raising the question of maintainability. And then you go on and answer the questions raised. Whenever, moving on, whenever a state law is there, you know that state law, state rules, service rules, for example, are not available with the honorable judges at home. Your paper books, your SLP paper books go home one day earlier, 2 days earlier for the honorable judges to read. You would always like to enclose a complete copy of those rules or the state enactment. Or if it is too bulky, at least the relevant part, the cover page of the rules or the local state act, and the relevant sections, the relevant chapter, so to say. The honorable judge has a idea. From your examination point of view, you get a service law matter to draft, and there are Kerala service rules, medical education rules, 1956. So while you're drafting, you're enclosing that, you're showing awareness to your examiner that yes, there is an importance of enclosing the state enactment. I would now welcome your questions in the chat box, and would endeavor to answer them.
Can we paginate synopsis in the exam? Should we write?
Ye- Yes, certainly do. Certainly do. Give a hypothetical. Uh, the answer is to your first question. Indicate pagination, and because the entire paper book is not there, so just say that and leave the page blank.
First question is, if the question says draft the complete SLP, expected to draft the certificate miscellaneous application, etc.
Yes, if it is a complete SLP, then what is meant is with the affidavit also, with the affidavit with all relevant annexures and with all relevant applications also, starting from memo of parties and also the certificate. You already know there's a certificate enclosed, so the examiner is looking to see whether you have an eye for details. What is that?
Previous lectures have highlighted the importance of certificates, especially in drafts of petition, which are commonly skipped. So are they important?
If the question says complete SLP, then it is with the certificate. If he says SLP, if he says SLP only, then certificate is an appendage to the SLP. Then you may skip the certificate.
He's asking how to annex the annexures by saying concerned document enclosed.
Yes. Suppose I say plaint, civil suit arising from a civil suit. So I'll say,
Copy of.
I'll say plaint and full stop, copy of the plaint enclosed, copy of the plaint dated so and so enclosed
Next
is annexed
as an extra.
as annexure 1, then a written statement, copy of the written statement enclosed as annexure 2. That's how I go.
If counter affidavit is required to be drafted, should we draft affidavit?
Counter affidavit is already in the form of an affidavit. You see, when I start the counter affidavit, I'll start like this: I so and so, son of so and so, resident of so and so, do solemnly here affirm and so, and then I say I'm respondent number 1, and then I go on to say preliminary submissions, maintainability, and then I say that this is wrong and this is the correct matter, and then I say this is a relevant section, this is a relevant rule. I enclose, and then I close the affidavit by saying that the specially petition may be dismissed and the contents of this affidavit are true to my knowledge, whatever the format, and then deponent. So the counter affidavit, as the name suggests, is the affidavit itself.
You are asked to only draft synopsis grounds but not list orders. If we state in synopsis the annexure in non-chronological order, will it be okay?
No. In synopsis, annexures are not mentioned. Synopsis is, say, 2 pages. Synopsis running into 5 pages, 10 pages, not required. Because as I said, 2 points and the best points. And there's no provision for labeling annexures in the synopsis. Annexures are mentioned only in the list of dates.
What's the pattern?
Pattern of the exams I won't know, and this is complete answer because as you know, I am not one of those who have set the papers. Even if I was there, you know how much I could have disclosed to you there.
Listing performance also need to be drafted.
No, not listing performer unless asked for specifically. Listing performer is not is again an extra to the SLP. It's not part of the SLP. The question will be very clear. SLP means SLP proper. Complete SLP means everything. Complete SLP will still not include listing performer. So some light on commercial petition drafts. See, commercial petitions, suppose arbitration. Suppose arbitration. Makes no difference. Makes no difference. You have identified that what is your best point. You have said, suppose this is an SLP against on merits. the award has come, then it was challenged under 34, then it resulted in a commercial court appeal under 37 of the act, and then now coming to Supreme Court. It doesn't make a difference to what we have discussed earlier. You will again pick the best 2 points, you will again give the heading.
How to differentiate between writ appeal and SLP?
How to do writ appeal and SLP.
I was trying to say writ petition.
Drafting.
Writ petition and SLP.
No difference. No difference. Only thing is, you will know that when you're drafting a writ petition, that you're invoking Article 32, and this is the original petition in the Supreme Court. So you know, as a practicing lawyer, that your court is very reluctant to take a petition under Article 32 direct to the Supreme Court. The first question in their mind is, why not go to the High Court? So you would like to address that in the forefront. Always very pertinently, very appropriately asked, address that thing which your judge would look for right in the beginning. In this situation, he would be looking for an answer, why not a writ petition in the High Court? So suppose this is an all India railway strike matter. All India class 4 employees of the Indian Railways have gone on strike. I'm taking analogy from a reported judgment. So you would say, because this is an all India matter, and say various petitions have been filed in the various high courts which are all pending and which can give rise to conflicting judgments, therefore this one is being filed under 32, so that to have an authoritative opinion of the Honorable Court. You are addressing the first question in the judge's mind, that why 32, why writ petition, why you could not go to the High Court. Apart from that, I don't see any difference. Again, your best 2 points will come in the synopsis of the writ. After you have explained the maintainability, then your best 2 points will come. Your questions of law will come, your prayers will come. Of course, the certificates, those certificate will be different. It won't say that all documents were enclosed in the High Court. There was no High Court. Mutatis mutandis, that change will come. But the outline will be the same.
Relevant provisions will be given in the paper.
Well, relevant provisions of law would be given in the question paper, which the examiner wants you to examine. I saw the papers myself last 5 years. Sometimes I found that detailed sections were quoted one after the other. Then examiner is looking for your input on that. He is given it for a purpose. So he would like your input on that. For a purpose it has been given. If not given, then students are not expected, even lawyers are not expected to memorize questions of those provisions of law. Then you will answer it vis-a-vis on the basis of material available to you in the question paper itself. That is your encyclopedia. That is your factual basis, and that will be expected of you. These are the facts, these are the law. This is the question complete. So now please answer, the examiner will, and from that one is expected to answer. That's the expectation.
To draft a company application if not specifically asked.
Company application?
Accompanying application if not specifically.
No. Suppose drafting of accompanying applications. The question will guide you. The question says complete SLP. Then it's different, because SLP is not complete without applications. SLP is complete without a listing pro forma. But SLP is not complete apart from accompanying application. Suppose one line said in the question that certified copy is still not made ready by the High Court registry. And he says, give the accompanying applications. The question says, now you know, application for exemption from filing certified copy is what is required of you in addition. You'll do that.
SLP is limited to 528 excluding index and other necessary attachments. SLP is the main synopsis.
Should only SLP be limited to Form 1, excluding index? What do you mean by that?
SLP includes only the synopsis and everything, not index, memo pattern.
SLP will not include index. Yes, will not include. You're saying one question is from Ayush Anand. Prayer clause of SLP. No, this is peculiar in this court. You would not find it in the high courts. Of course, this is appellate SLP. So the format is grant special leave. Prayer clause, first prayer clause in the SLP. Grant special leave from order dated so and so, passed by so and so high court in so and so writ petition. That is the only prayer. Any other relief. Now this has become a standard. Why? Because the notion is that your prayers in the high court are revived while you say so. That grant special leave. Here, as a petitioner, you're only saying grant me permission to enter the temple so that I can go to the next stage and argue the matter in detail. If you notice, and I can argue the matter in detail, please allow me to enter the temple, so to say. So the prayer clause is drafted accordingly.
Two same questions are there, that synopsis and list of dates are part of SLP.
You see, complete SLP will mean synopsis and list of dates. Otherwise, the question will say, I could set a question, draft only synopsis and the affidavit in an SLP. So now you know only synopsis and the certificate, no more than that. So please economize your time. This is a lengthy paper, 4 to 5 questions you will need. And this brings me to be very precise. Be very precise. Be very mathematical in your presentation. This brings an interesting question. As far as possible, make your presentation mathematically, bullet point presentation, tabular presentation. Pedigree is there, for example, present it like a pedigree so that the judge can read it at a glance. You want to present facts like at what point of time various payments were made. So rather than a narrative, you would like to say that serial number 1, 2, 3, 4, 5, and then you'll say on date so and so, rate of interest so and I paid so and so amount. Balance so amount remains so and so. Next entry, I next paid after 10 months, amount I paid so and so. At that time, the interest was so and now the balance outstanding was so and so. So this, at one glance, this chart helps you in court and saves the time of the examiner, and he knows you're doing a mathematical and a precise presentation. Please go on very precise drafting. I don't mind an SLP with 2 grounds. No, if those are the only 2 grounds, your judge will also appreciate it as an advocate on record when you will graduate to you making very precise, raising very precise grounds. And no, I would say and suggest first, second ground cannot be High Court has failed to apply its mind. High Court has not considered the relevant factors. These are all generalizations. They'll be skipped over by the examiner and by the judge. First point, as I said, firstly, should strike him. Yes, there is something in this matter. Second point, should strike him. Yes, there is something in this matter.
Error on face of record and substantial question of.
The words for difference. Error on the face of the record. That notion is well understood when we are talking of a review. And substantial question of law, you know, it is in section 10, section 100 CPC or 260A Income Tax Act. That concept is being borrowed more and more in appeals to narrow down the scope of the appeal. That well, appeal will be maintainable only if substantial question of law. So that distinction you'll have to maintain. If you're drafting, a SLP from a civil suit, that is, that matter touched the High Court in a second appeal, so governed by 100, Section 100 CPC, and it was dismissed. So you're saying these following substantial questions of law arose. High Court has recorded, you will say in the last paragraph, quote, no substantial question of law arises, dash, 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 page 14, unquote. And then you will say, it is submitted that the following substantial questions of law arose. 1, 2, 3. And then you can say, brief, you can give the heading, brief background, brief factual background. And then you give the factual background. That is to say, in this factual background, now I'm going reverse. In this factual background, these questions of law arose before the High Court for consideration, and High Court has answered that no substantial question of law arises. So you are making out a case for notice when you stand behind the brief the next day.
Why should we mention the relevant rules and regulations in SLP?
You will mention the relevant rules and regulations in your grounds. When you're raising the ground, and that ground pertains to the relevant rules and regulations, there you will quote it, provided it is given to you in the question. And in your practical experience as a practicing advocate on record, you will of course have access to it. Then again it will go in the grounds. If it is so outstandingly important and you have access to it, then you might quote it in your synopsis also as a practicing advocate. Or if you have access to it, suppose you find it's outstandingly important point, you want to mention it as point number 1 and 2 in your synopsis, then you will say this was the requirement of the rule. The Chandigarh administration building site rules required 1956 in rule 14 said this, that fragmentation of the site is not permitted. Taking an example, fragmentation of the site was not permitted. And then you say, quote, when you quote the rule 18, and then you say the conclusion of the High Court is completely to the contrary, because High Court has permitted fragmentation. So the judgment is in violation of the relevant rule. It's for you to judge how important it is, how much earlier do you want the judge to read it. And you would like him to read it at a time when he can assimilate it. Give a brief background and then make your point. Brief background enough for him to understand what's happening. Imagine he has just opened your brief. Examiner has just opened your brief. He's looking at your synopsis. Carry him from there. Give him enough facts and then the point. Enough facts and then the point, so that he can appreciate.
Ground in respect of law or fact have not been taken in High Court, and the interim judgment also does not whisper of the same ground, it should be done.
You see, if you find a question of law or a fact which is very important in your judgment to be taken, not there in the High Court order, not there in the High Court order, not there in the High Court pleadings. Suppose not there in the High Court order, then you are in a difficult situation. It's not argued, and you will going to be faced that it was not in the High Court. Then you look for whether it was in the High Court pleadings. Suppose it was a writ petition or an appeal. Was it in the High Court pleadings filed? If it's there, you can pick it up from there. And you could take the plea. This is a question of law. So I could be permitted to raise that point. Or you could take the point that this was argued before the High Court, and High Court has failed to notice this particular point. Now you will need to say it very specifically in your SLP. That raises a very important question. Often you will be confronted with this situation. Quite often. You want to raise a point and that point is not in the High Court order. You ask your instructing counsel and he tells you that this was argued. then the Supreme Court expects you to very categorically raise this issue in the grounds that yes, it was raised and argued, but High Court has failed to notice that. It could also be a third situation that you are wanting to bring a point which was never argued in the courts below, never taken. Suppose registration, that this compromise deed required registration, and that's a question of law and supported by Supreme Court judgments. Then you will seek permission of the court that this is a question of law going to the root of the matter, and permit me to raise this. Why? Because no factual basis is arising, and I may be permitted to raise this question of law. Then you would like to file a specific application for permission to raise additional ground.
Adding solution also necessary to make adding then under the respective liability for purpose.
Oh no, the heading in the synopsis is not for the purpose of the exam alone. It's for your practical practice also. For the exam, it will help you, I would say, fetch better marking. You'll get better denominations from your examiner, because your examiner will be immediately able to understand that you're wanting to capture this point now. That heading takes him to the thought which is in your mind. That you are now on point A, then you're dilating on that. Now you're on point B, and then you're dilating on that. So he is able to immediately go to your thought waves. That's the idea. Therefore, I said, while I'm asking you to make headings and adding work to your task already, I'm trying to balance it by saying, be precise, use less words in your expression. You're using less words, you're thinking more, you're more focusing on presentation. I'll tell you, it takes me back to my college days. We had a very bright student, and she would, even in subjective papers, score very good marks. I still remember her name, Kalpana Lodha. One day, I was amazed even in theory papers, Constitution Article 14, write about arbitrariness, and she'll be getting 90%. One day I requested her to see her paper. When I saw the paper, even such a subjective question was answered mathematically, that this topic can be understood in non-arbitrariness, reasonableness, classification, grouping, Wednesbury principle. So she has divided it, a subjective thing, into a mathematical 4-5 headings, and then commented on each heading in 4 lines, 5 lines, 4 lines, 5 lines. She gets much better evaluation. The judge or the examiner knows she has addressed so much. She has seen these many facets of Article 14. That's what I mean to say.
A review petition draft fetch maximum.
Address immediately in a review petition, immediately address the vital thing, that the following are the errors which appear on the face of the record. The examiner knows you will only address that, and then you summarize in the beginning that following are those 1, 2, 3, that this for first error apparent on the face of the record. I'm just giving an example. 1, despite a clear admission contained in the written statement in para 14, High Court has gone on to record that the adoption of respondent number 4, the formalities had not been carried out. The admission in para 14 reads thus, quote, Those 4 lines are quoted. So this is an error apparent on the face of the record. If that para 14 was only read, it would show that all the formalities around the adoption was an accepted fact. What was disputed was something else. And now I'm getting non-suited on the ground that adoption not proved. Error apparent on the face of the record. Second this, third this. And then you will go to say the brief factual background is this, because your review has to be complete in itself. Then you will give a heading, brief factual background. This civil suit arises from in the year so and so, this adoption was challenged. Plaintiff enclosed this, enclosed that, enclosed. Trial court held this briefly, judgment enclosed, and then you complete the record. But you have addressed the most vital thing, what he's looking for, namely the judge or the examiner, that yes, this particular person is now addressing error apparent on the face of the record. Is this 1, 2, 3?
The relevance of Supreme Court rules in drafting.
Well, you need to, the relevance of Supreme Court rules 2013 in drafting is very much there, because it will give you the essentials of an SLP. I'm not addressing you on that. I'm addressing you on the finer points. I'm addressing you with court in mind. I'm addressing you with the examiner in mind. But what are the essentials? I'm sure you're going to pick it up from the rules itself. Read the rules. Let my SLP in the exam not be bereft of the rules. So kindly pick up those details from the rules themselves. The essentials of an affidavit, the essentials of an SLP, like memo parties have to be there. The heading has to be there in the Supreme Court of India, civil appellate jurisdiction.
Is it important to quote judgments in the draft?
Is it important to quote judgments in the draft? If you remember a judgment, never mind the citation. Suppose you are doing a matter challenging, you're on reservation whether for EWS, that extra 10% which has been validated by the Constitution bench recently, it's a question on that for economically weaker sections, and you remember the name of the judgment, you remember Indra Sahni, so you could simply say in Indra Sahni this so and so, and then you please underline Indra Sahni, highlight that. At a glance, your examiner knows you are aware of Indra Sahni. You may not remember the citation, that's all right. You may not even remember the name, that is also all right. You may say, this honorable court has taken a view in a reported judgment. So, if you remember the name or the citation, even better.
When we write headings in bold, black ink in examination.
No headings in black ink not required, same ink. You can write in caps, heading in caps, good enough. They should just stand out. Heading, some gap, and then your comment. Heading, some gap, and then your comment.
Guide us to frame a proper main prayer and interim prayer.
See, main prayer, you will of course pray all the relevant things. Many a times the court will come on the prayer. What is your prayer in the application, particularly in the application? Prayers have to be very, very carefully drafted. Alternative prayers have to be there. If not this, if 1, 2, 3, because who knows where things will settle in court. But your relevant prayers should be there. You're drafting a application in a pending appeal for mean profits. So you'll say grant mean profits to so and so, or you can say deposit, ask the respondent to deposit an X amount before this honorable court. That way you will keep your alternatives ready in discussion with your client in on the practical front, and on the examination front, what your question is asking of you. One question is,
SLP, so please give illustration on error on face in the
now we've already done that.
question of paper does not give the date of impugned judgment. How do we mention it without a date?
If it's not given, the date of the impugned judgment, then you can also say, when you're drafting judgment of the High Court, dated dash, wherever it comes, dated dash. No.
Any hint on what petitions and laws apply it is?
On what petitions and law to prioritize. You see, any hint on what petitions and Krishna Rao asks this. A hint on what petitions and laws to prioritize. For example, is a question on taxation law likely to come. I won't know. I told you, compare. Prioritize that petition in your question paper which you know the best. Do spend 5 minutes to go through the paper. Prioritize that question on the top, answer that as the first question. Again, first impression, best impression. Go on that. It should help.
Please read example to frame question.
How to frame question of law. And I'm being asked by Abhishek Gupta that an example of how to frame question of law. Okay. Question of law could be, when the defendant had, in a for specific performance, for example, when defendant, the seller, had failed to carry out his obligation under the agreement to sell, whether the plaintiff could have been non-suited on the ground that he was not ready and willing. Question mark, and I can say reference P.D. D'Souza, because I don't remember the citation. So I'll say judgment of this honorable court in P.D. D'Souza, because in P.D. D'Souza they had said that if the seller himself has not done what he was required to do, then where's the question of asking the plaintiff whether you were ready and willing? So the question I am framing is the question of law. Look at the format now. Whether the plaintiff could have been non-suited on the ground, could have been non-suited when defendant failed to carry out his obligation on the ground that the plaintiff was not ready and willing. Question mark. That's your question of law. Another question of law could be, when there was an interregnum of more than 2.5 years between section 6, between section 4 and section 6 notification issued under the Land Acquisition Act 1894, the earlier act, as you know, whether the said acquisition could have been upheld. That's the question of law, because the section requires that there can be no interregnum beyond 2 years between 4 and 6 notification. So therefore, this question of law gets formulated, that when there was a bigger gap, whether such an acquisition could have been upheld. There are 2 instances.
Between question of law and
Difference between Ashutosh, difference between question of law and grounds. Question of law is just what we did, just what we finished. Grounds are under Hindu law, for example. Grounds could be that the property in question ought to have been held to be proportionary property because it was inherited from the grandfather, it came in the hands of the father, and thereafter it was passed on to the plaintiff. In this, uh, in this light, paragraph 221 of Mullah Hindu law can be seen, and then if you have access to the book, that paragraph can be quoted. So your ground will go like that, and the reading of the question of law will be as a question arising in law. It is arising, facts are giving rise to it, but it has the shape of a question of law. I'll give you one more example of question of law. Probably that will bring in better light. Service law matter. And the period of ad hoc service was required to be counted. So question of law, whether in view of rule 26 of the so and so rules 1971, comma, the period of ad hoc service could have been disregarded. Period of ad hoc service followed by regularization could have been denied to count the actual service rendered by the petitioner. You have to see the format. Question of law is a different expectation. Grounds are a different expectation. So at different points, different things are being tested and evaluated also.
Question of law. Often I mixed question of law and question of fact.
Yes, no, Kunal, your question, no question of mixing question of fact and question of law. Question of fact is the facts of that case, which are peculiar to this case, the facts of that case. That is your synopsis. In other words, they are relatable to your synopsis. Questions of law has no place in synopsis. In your list of dates. Your list of dates is your facts. Your questions of law are in the SLP proper, where you find the heading questions of law. So that is where you formulate the questions of law. Grounds is still different. So all these three are different. So keep your facts in your list of dates. Your synopsis is a mixture of facts and law, and therefore you are giving your best foot forward right in the beginning. Why? Because the judge with his wide experience, by reading a small factual background, is able to understand the error that has come. Again, small background and the error that has come with his experience. So therefore you're keeping your facts in your synopsis, in your list of dates, and your questions of law in the questions of law, and your grounds are an outcome of a mixture of facts and law. In these facts, in this law, this is how the High Court has heard, is your ground. In this fact, in this law, this is the error the High Court has done. That's how you go.
Is any provision of law is provided? Do we need to reproduce the entire?
No, you don't need to reproduce the entire provision. Mr. Agarwal, you don't need to reproduce the entire provision because that will take a lot of your time. Not necessary. Just go ahead and answer the question. No, nobody's stopping you from making rough notes on your question paper. Your one question asked by Kunal is, how many questions of law and grounds to incorporate? Only as much as very relevant. I remember having filed an SLP with 2 grounds. No difficulty, because according to me, those were the only relevant ones. So brevity will stand for you, but be satisfied that these are the only ones arising. The very relevant ones. Be very, very precise. Be very concise. Your judge will appreciate it. Also while addressing also while addressing the court. This is just by the way.
There appears to be an error in question one attempt, or should we?
If you find there's an error, you can think of skipping that question itself, because my attention is going to get attracted there. I'm the student undergoing the paper. I think there is an error in the question. I would rather skip the question only and save my time. What is short title? What is short title include?
You assume that A versus B, if party's name is not given, it's cause title.
Cause title. It is saying from an intern to everyone at 5:14. What is short title include? Short title. Short title will include that a detailed memo of parties is not expected. What is expected is short title. A. Govardhan and others versus B. Raja and another. Short title. That's what is the nomenclature of a short title. Detailed title will be all the complete memo parties with address. Now Rahul is asking about curative. Now we've done this. Rahul, you know the answer. Curative, what is the honorable judge looking at? You know, there are 3 criteria in Hurra versus Hurra. 1. Undisclosed bias of the judge. 2. Principles of natural justice violated. 3. That otherwise in the interest of justice. So you'll have to make up your mind that you're going to put it in which slot. Just like we did the review matter. We said that right in the beginning that the following are the errors apparent on the face of the record 1, 2, 3. Now when I'm doing the curative, I have to be very careful. It doesn't have to be lengthy because nobody's going to read it. I'm not going to hold the attention. So right in the beginning that this curative has been filed and it is raising only those grounds which were raised in the SLP and were raised in the review. Why? Because Hurra versus Hurra requires that. It's a sine qua non. So the judge knows, yes, Rahul is well aware. 2. Then you'll say this petition is submitted because of the principles of natural justice having been violated. And then you will say how. Because in the departmental inquiry, the inquiry report and the documents placed on record by the presenting officer were not made available to me. And therefore, principles of natural justice violated. So you'll say that right in the beginning. And then you'll enlarge it that I raised this point in the SLP also, I at page so and so, then I raised it in the review also. And for the parent document, C 119, I'll say that when I filed my reply to the show cause, at that time I had said this. And when I argued this before the inquiry officer, before the punishing authority, that the inquiry officer report and the documents are not given to me, he said, well, these are all official documents and they cannot be given to you. And then you will quote that at page 143. This is the answer of the punishing authority. And this is the fundamental mistake, that you don't give me documents. How am I supposed to defend myself? You are the custodian of the document. You don't give me the documents. Therefore, and I raised these points in the SLP, and SLP has been dismissed in limine. And High Court had this to say. So, in 2 pages, you have covered that point and nothing else. You'll close your curative here. So, you'll very carefully select the point. And then, of course, you know the requirement of a certificate and this and that. You'll make it all complete.
original suit in Supreme Court.
Original suit in Supreme Court, no different. No different at all. Suppose interstate water disputes. Then you'll say, well, it starts from you're drafting a suit. I would say you'll give memo parties in the Honorable Supreme Court of India, original jurisdiction, this that memo parties you'll give, and detailed state government, state of Haryana, to the chief secretary, so and so Haryana secretariat, this that parties versus this, and then you will say this is under Article 133
Yes.
of the Constitution of India, this, and then you'll say brief factual background that there was a Matthew Commission, there was this, there was that, and there was an SYL matter which came to the court between Haryana and Punjab, and this was agreed. Then Punjab came up with a amendment act, and that amendment act has been struck down by the Honorable Supreme Court, and now the dispute is this. So you're giving the facts which are a run up, and then you're saying that why you have come up now, because now the tribunal has given this judgment which has to be challenged before this honorable court. And then you will say your prayer clause, you will give prayers as in a civil suit, prayers 1, 2, 3. The subject will not bother you. Once that format is clear before you, the subject will not bother you. You know you have to marshal your facts. You know you have to be precise. You know you have to present it mathematically. You have to give page numbers for convenience and for cross reference to the honorable judge or to the examiner. You know that. The tools are the same because it's drafting. It's an art. You will enjoy it. And the more you, let me tell you, I had a strange feeling that it's not fashionable in Supreme Court, as I would say, to be saying that I drafted this. I wonder why. It's a creative thing. You're creating a draft. You're creating what your judge will read overnight and come to the court, and then you or your counsel will be asked to open. You're creating it. So it should be very proudly taken up. It puts to test the best of your skills. And having done so well in your drafting, your presentation the next day in the court, when you read the same very draft, take it from me, when you read that very draft and you go to the court and you have the judge in mind, that it is before A, B, and C judge, your mind will further focus and make it even more concise. So that good draft is helping a better presentation. So all the more important. Give it very adequate importance.
Can we make assumption that certified copy is available, translation or official?
Yeah, you can assume that certified copy is available because confine yourself to the question. I as a student, if I'm sitting in the exam, I have no imagination beyond the question. What is the question asking me? I will answer that. That is the answer to all these things. That can I assume that certified copies are available, translations are official or not? Well, if there's nothing in the question, I don't have to look after that. That's not asked of me. Put it this way. That is not asked of me. That is not, I'm not being tested on that. What I'm tested on, I will answer. I think that will make life simple.
Should be a prayer in
A prayer in the curative is that that one, may you please to direct that this matter, that please to direct notice of this curative petition to the respondents. That's your first prayer in the curative. Second, upon notice, the judgment under review, judgment of review dated so and so, in review petition so and so may be recalled. Next, sequentially, order dated so and so, in SLP so and so, passed by this honorable court in this matter, may be recalled. Next, the specially petition may be directed to be set down for hearing before this honorable court. Very polite, very polite. Even if you have to say the harshest of things, which I'm not suggesting at all, even if you have to be very polite in your language, you can say plenty in what is expected of us in the exam or of in the SLB is very polite language. You can express yourself that this should not have been done, this should not have been said. Use all that flair, but language very polite.
If a review is dismissed after listing in open court hearing, should a curative follow?
Yes, it can follow. Reviews dismissed, open court hearing. It is dismissed in open court hearing. I don't think there is a caveat in Hurra versus Hurra. No, it only says that you have to travel through review. You can't come through SLP direct to curative. SLP, then review, then curative. These are the stepping stones.
Simple SLP means question of law, grounds, and synopsis.
Yes, simple SLP will mean
List of dates.
list of dates, will mean synopsis. Let's go sequentially. It will be easier to remember. Abhishek Gupta, it will be easier to remember. Simple SLP will mean synopsis, list of dates,
Question.
title, questions of law, grounds, prayer. That's your SLP.
Interim relief.
Interim relief is contained in that. You know that. What's it called? That heading is there. Ground for interim relief. That's your simple SLP. If I missed out any question, please type it in the last. I may have missed out a question while reading through. So if you could please type in the last. What about declarations?
Declarations are as per the rule.
Declaration that Supreme Court rules will guide you.
Yes.
Declaration. Kailash.
As the AOR certificate is compulsory while filing review petition, what about the review petition filed by advocates as petitioner in person? Or not where advocates signature will be?
AOR certificate is compulsory for filing review petitions. In petitioner in person, there can't be an insistence of a AOR certificate because he's in person.
Transfer petition.
There is a question by Ashish Kumar Das. Requirements in transfer petition. Well, you know already. When you're talking of Ashish Kumar Das, when you are looking at transfer petition, you already know that you are guided by section 2425 CPC, that what is the requirement, and then you have to make out a ground. So you can in the very forefront say this is being filed because by the wife, because she's 1400 kilometers away and she has a minor child to support, so she's hardly able to transfer to travel 1400 kilometers for every date of hearing. That could be your beginning of a transfer petition. And then you know the requirements. The rules will tell you. After the rules, I have already told, after the rules are there in your mind, which are common rules for drafting, then you only have to marshal the facts. I'm repeating myself. Any petition, marshal the facts, give heading, raise your grounds, give heading. Just make it easy for the judge to assimilate, or your examiner to assimilate your facts and see your grounds. And see them in least amount of time. Don't hesitate to underline also. In your papers, I can't say that for your petitions, but I can certainly, I think, say that for your exam, don't hesitate to underline. And don't, separate pen is not required, it will take up your time. Underlining with red. No. With the same pen. Because you're asking your examiner that just look at these 5 underlines. He knows you have addressed the relevant aspects. That's another way of helping your examiner to do speed reading. The more you help, the more you get the marks.
PI.
PIL. Rahul is asking PIL. PIL. Now Rahul, you are the judge. PIL. He's thinking why PIL at the why this PIL has been filed. Then you'll say this is a PIL because residents of Kurukshetra are bringing a grievance that the park, which has been in existence for 40 years, is being converted into a hospital, a 5-star hospital. And this petition is being brought by the residents in that area. So you have addressed the right question at the right time, right in the beginning. The locus. Because judge is thinking PIL, this has become a fashion, it may not be misused. So you're answering that question. Then again, you give headings, you marshal your facts. This was a park, this was constructed, this land was acquired, this was part of TP scheme number so and so, town planning scheme number so and so. Photographs have been enclosed, and now the municipal corporation has given it on lease, has issued a lease deed in favor of this private hospital. And on the site, the bricks have been dumped. Photograph enclosed. So again, you'll marshal facts, you'll marshal law.
Format of writ petition.
Format of writ petition. It was on format of writ petition. Whether form 32. That writ petition 32 should be used. I don't know what form 32 is, but format of the writ petition, there's no format. There's no format as such. Individual high courts have some essential requirements. You see, sometimes Odisha calls it OJC, original jurisdiction case. That's what I remember. Chandigarh will call it civil writ petition, CWP. Delhi High Court calls it writ petition, bracket civil. This is the nomenclature, writ petition number so and so. But format, no format as such. Individual high courts may have peculiarity that you'll have to see in which high court you are. But when the Supreme Court asks you to writ petition, so you're saying 32.
Article 30.
You're saying Article 32.
Synopsis.
You're saying memo parties. You're saying synopsis,
List of dates.
list of dates, and so on. And then you're raising your grounds, and then you're raising your prayers, and some essential averments you'll make at the end that no other petition was there, and that you have no other efficacious remedy, because you know, in a writ petition, if you have a departmental inquiry, departmental appeal, suppose taxation matter, and appeal to the tribunal was available, then you could have come to the writ petition. So you're saying that is not available. And if the tribunal is there, then you're saying that tribunal is not functional, and therefore I'm compelled to come in a writ petition. Those formal paragraphs are there. You'll have to address that.
Last question. What kind of drafts are important for your exam testing?
What kind of drafts? I only told you I know nothing about. I was not in the paper committee, in the paper setting committee. I wish I was there. Next time, make sure I'm there. I can't help you with that. Any other questions? Most welcome. Okay, so thank you very much. I hope I've been able to contribute a little bit here and there.
Thank you, sir.
All the best for your exam. I wish you all come out with flying colors, and see you as colleagues. You're already colleagues in the Supreme Court bar. So all the best.
Thank you, sir. Thank you very much.
Thank you.